The session, today's session is titled COVID-19 Force Measure. Can parties renegade from their contracts? It is going to be presented by Vyapak Desai, Simone, Reis, Kshama, and Ashish Kabra. Before the session will last for about 60 minutes, of which the first 30 minutes will be spent on the panel discussion. The remaining time will be available for question and answers. We request all our participants to post their questions in the chat window. The presenter will queue up the questions for the speakers accordingly. We request participants to keep writing questions while the panel discussion is on. The presenters, please note that the presenters will take up your questions at the end of the panel discussion. This being the inaugural session, we would like to invite our founder, Mr. Nishith Desai, to say a few words, and then we will start with the panel. Nishith, I request you to please inaugurate today's session.
Thank you very much, Devanshi. Appreciate inviting me to this inaugural session on force measure. Before I start, let me tell you that our hearts go out to the victims of Corona-19 in the different parts of the world. I would like to convey our sympathies and condolences to those who have suffered the consequences of the pandemic. As you all know, that we are a research-based and innovation-based law firm, and we have operations around the world, and we thought it would be useful for our audience to understand the consequences that are widespread as far as the legal ecosystem is concerned, and they would like to know what's happening and what is the position in particular. And we thought that it would be good to have this global conference on the web. And we are in the technology age, and we are now known as virtual NDA. And we thought it would be useful to have this kind of program so that we make the best use of the opportunity. Every crisis, also brings a new opportunity. And I recall what Shakespeare said: all the world stage and all the men and women merely players. They have their exits and entrances, and one man in his time plays many parts, his acts being 7 ages. So world is a theater. That's what Shakespeare said long ago. And we thought in a virtual world we can do something together. I'm really grateful for all of you to have joined us this afternoon. In fact, thank you for participating in hundreds today from all over the world. And indeed, we are overwhelmed with your response and encouragement. We are always delighted to help you in whatever possible way we can, in whatever little way we can. But today is an opportunity to at least educate and empower our clients and our acquaintances so that we can create a better world and together. With those words, I would now request Vyapak Desai to take over the proceedings and move on. Thank you so much.
Okay. We welcome Vyapak Desai, who is the session presenter. He is the leader and head of our International Dispute Resolution and Investigation Practice. We also have Ms. Simone Reis. She's the leader of Private Equity and M&A Practice. We have Kshama Loya, leader of, again, International Disputes Resolution and Investigation Practice. And we have Ashish Kabra, who is the leader and based out of our Singapore office, also a part of the International Dispute Resolution Practice. Thank you. Vyapak, we request you to start with the session.
Thanks, Devanshi, and thanks, Nishith Bhai, for the invite. I think this is the first time even we are holding such a webinar, sitting across different offices, different houses, not offices this time, and we are in different jurisdictions as well. So we have Simone, we have Kshama, and we have Ashish from Singapore. So please bear with us if there are any technology issues or otherwise, but we'll try and make this very, very fruitful. So straight away, jumping into the session, what we plan to cover today is in 3 different parts. One, we would like to have Kshama to generally explain the law, what it exists in India. A lot has been discussed on force majeure, particularly in the COVID-19 situation, but there is always a difference as to how we understand commercially versus how the law prescribes. So we will have Kshama to talk a little bit on that. We will have Ashish, who would give a little more practical experience. So we want audience to also get little bit of an understanding, depending upon the facts of each case, how would this force majeure work, or I may say don't work, in situations where you cannot invoke force majeure. And 3, we would also go into the aspects of M&E, at least touch upon a few of them, particularly in the context of material adverse change, the MAC clause, as we know, and Simone would guide us on some of those questions. Everyone who has any question, please feel free to put it on the chat window. We may take it up after some time, maybe around by 3:30 or so. But it would be good for us to know as and when the questions are queuing up. So, Kshama, my first question to you, as we understand force majeure, I think the Indian law obviously has 2 different parts to it. My first question to you is, when we see a force majeure clause in a normal contract situation, right? And this is having a force majeure clause in a miscellaneous section tucked in is a common phenomena. So when you have such a clause, how does the Indian law apply? Can you give your thoughts on it and any leading judgments which gives a guidance on the jurisprudence and so on and so forth?
So in the context of COVID-19 and force majeure clauses, we are seeing that performance in contracts is either getting difficult or impossible. It is an event which was not foreseeable by the parties. So majority of the commercial contracts today provide for such unforeseen contingencies. They are titled as force majeure clauses, as Vyapak mentioned. This is a Latin term. It translates into a superior force and could be defined as an event or effect that can be neither anticipated nor controlled. A normal force majeure clause or an FM clause would state none of the parties shall be liable for any failure in performance due to force majeure events such as act of God, fire, flood, earthquakes, accidents, act of governmental authorities, riots, strike, lockout, or any event beyond the reasonable control of any of the parties, which hinder the performance or render it impossible. Now, when a contract provides for unforeseen contingencies, Section 32 of the Indian Contract Act comes into play. It is titled Enforcement of Contracts Contingent on an Event Happening. The provision states contingent contracts to do or not to do anything if an uncertain future event happens cannot be enforced by law unless and until that event has happened. If the event becomes impossible, such contracts become void. So according to an FM clause, the contract would stand suspended or discharged on the happening of a certain event. If performance is impossible only for a limited period of time, say 60 or 90 days, which is the standard, while the event is subsisting. So according to an FM clause, normally performance would be suspended during the time that the event subsists. And then the parties can resume performance after the event ceases to operate. Now, the term act of God is often seen in such FM clauses. Act of God is defined as an extraordinary occurrence or circumstance which could not have been foreseen and guarded against due to natural causes. However, force majeures also held to have a more extensive meaning than act of God and could include occurrences such as strikes, breakdown of administrative machinery, effects of act of God such as lockdowns, shortage of supply, refusal of export license even. Or some force majeure clauses could also contain generic terms such as any other happening. Now, can a pandemic such as COVID-19 be interpreted as an act of God? Or can the effects of shutdowns due to COVID-19 trigger the force majeure clause? This would depend on the language of the clause and the rules of legal interpretation, such as the nature and general terms of the contract, the events which precede or follow it, and the facts of the case. In light of COVID 2019, in February this year, the Ministry of Finance issued an office memorandum on force majeure clause, which is quite pertinent to note here. The memorandum states coronavirus should be considered as a case of natural calamity and force majeure may be invoked wherever considered appropriate following the due procedure as per the memo. Now, this may not serve as a binding document in every case. Courts or arbitral tribunals, if a dispute arises, would interpret the clause in contracts and assess if the same covers this contingency. Since this is a contractual provision which a party can elect or choose to invoke, the party would need to follow formal requirements to invoke the FM clause. Generally, notice intimating commencement and end of the force majeure period. Let me just quickly compare this with English law and New York and Delaware law. Under English law, akin to Indian law, force majeure derives its existence from the contract. Parties need to prove that the event is unforeseen or was unforeseen, and there is a direct causal link between the event and the non-performance. Under New York law, force majeure clauses are construed very narrowly. Only events listed specifically in the FM clause will excuse the party. Similarly, under Delaware law, FM clauses provisions are interpreted as per their plain meaning. So, COVID-19 would be covered only if the FM clause includes specific language relating to public health, such as epidemic, pandemic, plagues, emergency, outbreak, serious illnesses. So, that's a
Sure.
very brief introduction on force.
So, Kshama, that's correct. So, Kshama, I think what is important to know is if you have a force majeure clause, then you fall under Section 32, and then it will be very important for one to interpret what it covers and what it excludes. And therefore, your drafting of force majeure clause becomes that much more important. That only means that from a section which is miscellaneous in a contract covering force majeure, I guess after COVID-19, there will be enough negotiation around this clause as well, because now people know how to cover COVID-19 kind of a situation, particularly when it has already become a forcing situation rather than an unforeseen situation. But tell me one thing, there are many contracts where people don't negotiate or don't draft the force majeure clause. Are they left in lurch? Do they have any remedy left, or Indian law as usual comes to their rescue?
Indian law as usual would come to their rescue. And under Section 56 of the Indian Contract Act, impossibility of performance after execution of a contract is covered. Section 56 is titled Agreement to Do Impossible Act. Now, the first portion of this provision would not apply. The second would, and I'll just state it for the benefit of our listeners. Section 56 says an agreement to do an act impossible in itself is void. Now, the second para is relevant, which states contracts to do act afterwards becoming impossible or unlawful. A contract to do an act which after the contract is made becomes impossible, or by reason of some event which the promisor could not prevent becomes unlawful. The contract becomes void when the act becomes impossible or unlawful. Now, impossibility and frustration are often used as interchangeable expressions. So in a situation where there's no force majeure clause, Section 56 and the doctrine of frustration could come to the rescue of the parties. Under English law, frustration is a common law doctrine. It is concerned with change in circumstances that can wholly destroy the very object or foundation of the contract or make performance fundamentally different from what the parties contemplated in the beginning. Hence, under English law, one needs to establish frustration by applying certain legal theories formulated by English courts. Now, these would involve implying terms into a contract or vesting courts with power to determine what is just and reasonable, or engaging in a construction of the contract based on intention of parties. However, under Indian law, impossibility or frustration has been covered statutorily under Section 56. So, this is a positive rule of law on supervening impossibility or illegality that would render performance impossible. So, unlike in English law, one would not need to look at intention of parties or what is just and reasonable, but whether the unforeseen event has made performance completely impossible in its practical and not merely physical or literal sense. So, if a party can prove that the unforeseen event has completely destroyed the object of the contract or fundamentally changed the nature of performance, then the contract would be said to be frustrated and it would automatically come to an end. Now, under New York law, the defense of impossibility is only available when performance is objectively impossible due to destruction of the object of the contract. So, this is similar to Indian law, but it would be quite difficult to invoke this doctrine under Delaware law. So, that's on Section 56, where a contract does not cover force majeure clauses.
Sure. So basically, you are still not completely, out of any option if you don't have a force majeure clause. But then if you have a force majeure clause, then you obviously have to look at 32 first. And if that is not something which is applicable or your force majeure clause is not clear, then you might want to look at 56. Now, in this context, I think the law obviously is one thing, but the practical aspect is the another. So what we thought was we have a very brief practical example which we want to run through between this group. It may cover a lot of situation. It may also leave out some of the factual pattern. But idea is to give a little contextual response to COVID-19. So, Ashish, may I ask this question to you based on an example which I have thought of? So let's say there is a long-term supply agreement of goods or chemicals from a foreign country to India. And the supplier who is sitting in one of the COVID-19 affected countries is not able to, let's say, procure or produce the chemical due to non-availability of workforce in that country. Plus, there may be an issue on cost of transportation or limited number of transportation options available. There is a force majeure clause in this case, in this hypothetical case. And it says if either party is prevented wholly or partly from performing its obligations under the contract due to a natural disaster, war, riots, or any other reason beyond reasonable control of the party, then upon such party giving notice to the other party within a reasonable amount of time after the occurrence of the event, such obligation shall be suspended. Now, this is the clause that we are interpreting. What is your view? What can supplier do? Can he claim force majeure and suspend its obligation just because the facts as it stands today in the world are there in front of the party?
Sure. Firstly, thank you everyone for joining our webinar today. Unlike everyone else, I'm here in Singapore and addressing you all from this place. Situation is still, people are still allowed to reach office in Singapore. But coming to the fact pattern, Vyapak, that you were discussing, Now, the first part of the analysis of how we progress is to look, in this case, you pointed out that there is a force majeure clause. So our analysis would start from looking at that clause. As I understand, the word epidemic is not expressly stated in the clause, but the clause does have a broad language or a generic language which says situations which is reasonably beyond the control of the parties or something similar, as I heard, uh, can be taken advantage of, can be relied upon. So it is likely that the current situation or that the issues that you pointed out, that let's say the non-availability of workforce or something can be brought within the ambit of this clause. So the absence of word epidemic will not disentitle you from claiming or trying to seek protection or shelter under this clause. Now, having looked at the clause, the main part of the analysis would proceed towards to identify the causation. That is, how is one actually prevented from performing its contract? I understand you said two factors. First one being that the chemical could not be produced because there was non-availability of workforce. And the second is that there was increase in transportation costs due to limited number of cargo ships for transporting that particular product or that good from whichever other country to India. Now, the first aspect, at least, non-availability of workforce due to the current circumstances may stand the test and can be brought in and be taken in defense of, and party can rely upon it to say that the performance was prevented due to such circumstance. But let's say if the buyer is able to show that the seller already has that chemical produced and kept in the stores and has that stock, so then the issue will, the causation will not be around non-availability of workforce. Then the causation would be inability to supply that product which is already in existence due to increase in shipping costs. Now, in that circumstance, the seller may not be as well placed as in the earlier one, because as under the law, a commercial impediment may not always come in and allow a party to claim force majeure. And if there are practical ways of performing the contract which is there, then it is likely that the court or the people, you may still be required to perform that particular contract. Therefore, it is very essential to look at what's the cause which is preventing you from actually performing the contract, and how is that covered within the clause. Having done that, the next step would be, let's say, as we noted, that non-availability of workforce is something that can be covered by the clause. The next step would be, what steps do I take now? That would be the next question. And we look at the clause. Typically, it will have a notice requirement. And in this case, I understand the clause said that the notice is required to be given within a reasonable amount of time after the occurrence of the event. Obviously, this could have different interpretations. Again, what is occurrence of the event? Is the occurrence of the force majeure event, or is it the actual performance being prevented? Different ways it could be looked at. Typically, it's safer if I'm on the supplier side to give notice as early as possible, because delay in sending any notice could entitle the other party to claim damages for the period where it could have avoided performing the, or it could have taken steps to mitigate any losses which a timely notification would have allowed him to do, and which it did not do so if the notification was delayed. And the last is, if I've notified, what's the consequence? And again, it depends upon the express language of the contract. In this case, the force majeure clause talks about suspension. Therefore, the supplier will have the ability to suspend performance, but not entirely terminate the contract. If, let's say, the force majeure clause was not there in the contract, then if somebody had relied on section 56 and not section 32, then the impact could have been that the contract would have been discharged and not merely suspended. So a presence of force majeure clause also has an impact on what consequence is there. But that's how I sort of look at this problem.
Sure. So I think there will be obviously several different questions, and I'm seeing on the chat window there are quite a few questions which are already coming up. But hold on to your horses. Just give us a little time to explain this concept, and we'll definitely try and address as many as we can. But I just want to touch upon another fact pattern here with Ashish, that one is supply of goods and services, right? And there will be hundreds of kinds of examples and fact patterns. But more importantly, we have seen a lot of construction and infrastructure projects will get affected because of this event. So let me give just 2-3 lines of facts where, let's say, the construction is obviously impacted due to reduction of workforce, non-availability of raw materials or equipment, and there is a delay by the employer in even obtaining certain licenses because government offices are either temporarily shut or working at less capacity. How do you see this kind of situation getting addressed? Does FIDIC contracts give a better solution? Does normal contractual requirements cover this situation? Ashish, if you can give a very quick response to some of those situations.
Sure. So in a construction context, the situation becomes a little peculiar. Let me say almost all construction contracts, including FIDIC standard form contracts, have force majeure clauses, which are generally well detailed out. And therefore, you would look at those force majeure clauses to see the impact. But without now going into it, construction claims pose a peculiar issue because, and it depends because the contract's extremely comprehensive. In that sense, there are two typical remedies which normally follow in any construction contract. It's either you claim extension of time if you're representing the contractor for the delay which is being caused, and along with this extension of time, you try and claim costs. And it could be that different contracts have different implications in relation to the force majeure clause. A FIDIC contract lists down various circumstances in which a force majeure situation could allow you to claim both extension of time and costs. However, epidemic is not one of those situations. So if you're looking at this type of situation, you may only get extension of time as a contractor, but not costs. But now there's an interesting part over here, and this is where parties could need to evaluate their contracts more importantly. For example, FIDIC contract for any change in law leading to it can allow for adjustment in costs as well. If any change in law causes any delay, it allows contractor to go and claim adjustment in costs. Now, we have seen government coming out with notifications. We heard about Kshama talking about a Ministry of Finance notifications. Now, there could be, but those were in relation to government performance, but there are also equal notifications in relation to labor work. Can a labor come onto the site? Government will have notifications restricting the labor movement. Now, if someone can then go and argue that there is a change in law which is causing impediment in the performance of contract, then they may not just be able to claim extension of time, but also costs. Similarly, in context of employer, because I think one of the reasons that you pointed out, Vyapak, were the employer not able to get licenses due to government offices being shut down. Now, typically, these type of consequences would allow contractor to claim both EOT and costs, and that's what the contractor will try and do. Employer, on the other hand, will then go under the force majeure clause and try and restrict the contractor to only an EOT claim and not a cost claim, saying it's a force majeure situation, not, for example, in FIDIC, not falling within those specific circumstances which allow you to claim both, and therefore you are only entitled to time. Therefore, especially in construction contracts, it's important to look what the contract says. It's very critical to understand how you frame your claim and what is that factor which is preventing you from performing, as the consequences could significantly vary. At one end, you only get time. At the other end, you get both time and costs. So therefore, people should be extremely careful while analyzing their contracts.
Sure. So while we were struggling to find examples, Ashish, I think on the chat window, I can see at least Rajiv, Vikram, everyone has given several examples, and we'll take one by one and try and see if we can answer them. But before that, maybe Kshama, you can also look at those questions, and if you're ready with some, or Ashish, if you can look at those questions and you are ready with some, you can let me know which question you can answer. But in the meantime, while Ashish and Kshama are working online for the questions posed by Rajiv and Vikram and several others, let me bring in Simone, who is ready to answer some of my questions. So one is the business of goods and supply and construction, and another is business to buy and sell business itself. So Simone, in a situation where you deal with an M&A, force majeure has a very different concept. It is generally governed first through a MAC provision, which is material adverse change, and then there are issues related to commercial impossibility versus practical impossibility versus whether the situation actually affects the M&A, because it is something which is on the date rather than in relation to any future effect. So can you give very briefly the concept of MAC and how current situation would affect some of the M&A deals which have already been signed but not closed, or which are about to be negotiated and signed, and how would COVID now creep into those contracts as well?
Thanks, Vyapak. So I think let's just quickly begin with what an MAE clause really is. And an MAE clause is, as you rightly said, is basically giving the acquirer an out to do the deal if an event or circumstance has occurred which is materially adverse to the business or financial condition of the target that it wishes to buy. Now, key to this is really the words material adverse change. And I'm going to stress on the word change because there has to be a change in circumstance that leads the acquirer to be able to call an out in an M&A transaction. Now, in the context of an M&A transaction, MAC is viewed very differently because the M&A transaction is an arrangement to buy a specific asset, given a certain financial condition of the company, and it is a one-time contract. It is different from a services contract, which is perhaps ongoing. It is different from a goods contract, perhaps, which involves performance of a good later on. But an M&A contract, typically, you would know from a time-bound manner what this really is, and therefore MAC does play a very important role. So typically, the way it's drafted is that it is an event or change that is or could be expected to be materially adverse with business, financial conditions, prospects, operations of the company. But very importantly, when you typically draft a MAC clause, it does exclude changes that occur as a result of a general economic situation that do not affect the target disproportionately from others in its industry. So this is typically an exclusion that is drafted in a MAC clause. So therefore, in the context of an M&A, first we need to look at to see whether there is a MAC clause, and if there is a MAC clause, then how really is it drafted? Are there exclusions? Is it specific, or is it really general? Let me tell you that the MAC clause is a very there's a very high standard to be sort of met to call a MAC. To call a MAC out and to try and renege from a contract. In fact, it was only, I think, in 2018 where the Delaware courts actually, in the acquisition tried by Phineas over Acorn, agreed that there was a MAC clause in the arrangement and allowed for Phineas to break that agreement away. So there's been a lot of debate of what a MAC clause is, but the threshold is very high. Now, there are three different types of MAC clauses, really. One is the target business MAC clause, which is what we just discussed. The second is a market MAC clause. Now, especially in public M&A, and especially in deals that involve the public markets, you would typically see brokers trying to also put in a MAC clause which has a dependency on the stock exchange, the markets in terms of how they're doing, because a lot of pricing, a lot of buying on the stock market also depends on what the volatility and how the exchanges are really functioning. whether there's been a freezing, whether there's been a trade restriction, and many of these things we are seeing today, right, on NSE, BSE. So I think a market's MAC clause is also needs to be looked at. And then last is really an acquire MAC clause, which is not often negotiated. Typically, MAC clauses in an M&A are more related to the target business, but not necessarily an acquire MAC clause. And an acquire MAC clause is specifically important because if an acquirer today needs financing to do a deal, and that financing is constrained, can they really call off the deal or call off the contract because they themselves were not able to achieve financing as a result of the material adverse effect. So there are three very different kinds of MAC clauses, and we had some sort of semblance in the Apollo Cooper deal where it was alleged, although the deal broke off for various reasons, it was alleged that Apollo's sort of ability to finance was a question mark. So in short, let's go back. Let's sort of go back to COVID-19 and whether really COVID-19 can be can have any effect on M&A transactions. We talked about the first word being change. Now, it depends really on whether or not you've entered into this contract pre-COVID area or post-COVID area. COVID-19 today, if you've entered into a contract maybe in December, you could try to see whether or not COVID would affect your arrangements. But given the high threshold and the high standard, a MAC clause has to be viewed as something more, has have a long-term sort of effect. It can't really be a blip in the revenues or a blip in the EBITDA. And the way we're standing in today, given it's too soon to tell whether or not COVID can really be used, or the effects of COVID could really be used to call a MAC out in M&A transactions. More likely than not, it'll be more likely no than yes. As we look at COVID today, because we don't really know the effects, it is too soon to tell. A situation, for instance, if you had to maybe enter into a contract in a post-COVID area, remember the word change. You perhaps are aware of what COVID could bring about. You perhaps are aware of what really, the COVID-19 virus could have an effect on the business, and therefore it'll be even more difficult to argue that in a post-COVID area that COVID really could be a MAC out in an M&A transaction. But having said that, I think there are various things that also need to be looked at in terms of, for instance, assume today you were buying a company where the revenues today were stalled as a result of, for instance, what the Maharashtra government has done and by imposing the Section 144 order. In this situation, you would, what has really happened is all industry manufacturing that is non-essential is really stopped, and therefore revenues could take a hit. Now, if you had to consummate and assume this is a situation where you've entered into a contract, pre-COVID area, maybe in Jan, and you need to consummate the deal before March 31st. Now, given that the manufacturing sector has stopped for a week or 2 weeks, perhaps it's not sufficient to say that this is really, a MAC out because you don't really know the consequences. But assume today you have entered into a contract in Jan and your deal has to close maybe in June, July, August. We may have a very different sort of, argument of view at that point in time, depending on what the outcome really is. So really speaking, the MAC clause, given that it is really a contractual term that needs to be looked at carefully, the devil really lies in how the clause has been drafted to see whether or not there is a MAC out or not.
Sure. So, Simone, I think obviously this requires quite a bit of questioning from my side as well. But considering there are a lot of participants who already have posed questions that they possibly are facing or are thinking as to how those would be interpreted in the context that they are looking at, maybe we can address some of those questions now, since we are almost 30 minutes down the time we started.
Sure.
And then maybe come back to you on some follow-up questions on NAC as well. So let me go back to Kshama. And I think there are 2 or 3 lines of questions which possibly we can answer, and Kshama can, answer them. So first, obviously, I think there was a question as to who has issued the memo. It is the memo, if you are referring or we are referring, which is 19th February 2020. It is issued by Ministry of Finance, Department of Expenditure. The questions which I gathered are one which clearly requires the participant to get a little better understanding on difference between frustration and impossibility. And I think there are examples which have been posed which leads to basically, if I may put it in simple terms, as to whether practical impossibility would lead to frustration, whether it is in case of rental or in case of lender agreements and stuff like that. So maybe Kshama, if you can first, in a very quick response, explain the law a little bit again as to how 32 and 56 work. Particularly, what's the difference between frustration and impossibility? And then maybe you can take 1 or 2 examples to explain.
Sure. So Section 56, which deals with impossibility, is a larger section. It has a larger ambit. It will cover supervening impossibility or illegality and basically any kind of performance that can be practically impossible or would by government action become illegal. Frustration is merely a subset of this larger doctrine of supervening impossibility. So when does frustration happen? We understand the confusion because frustration and impossibility is used interchangeably. But frustration will only occur when there is absolute impossibility, when there is no means to partially perform, when the contract is completely frustrated. Whereas a supervening impossibility or illegality under Section 56 would cover many more things. So that would be the one difference between impossibility, which is larger, and frustration, which is a subset where the foundation of the contract has to be destroyed in order to invoke frustration of contract under Indian law. Does that answer the question?
Yeah. Maybe we can wait till, I think this was, if I'm not wrong, question from Vikram or Ravi, if I'm not wrong. But maybe we can move on to the other part of the question. And there is an example given that in many outsourcing contracts, client requires vendor to use best efforts to mitigate fallout of a force majeure event. And any thoughts on how legally enforceable this is? Now, just to let the audience know, we will be covering IT sector as a whole today at 9 p.m. And more in detail. But maybe, Kshama, you can give a very quick response to this. But this topic will be covered much more in detail by my colleagues, Gauri, Vaibhav, and Vikram at 9 p.m. today.
All right. So, for that, a force majeure clause is a contractual provision. If you don't have a force majeure clause in the contract, it cannot be invoked. If you have the clause, then it has to be invoked in requirement of the formal ingredients of that provision. If a duty to mitigate or a best endeavors clause is a part of the force majeure clause, it absolutely will be looked into by the court. If a party who's trying to excuse itself from non-performance is seen to have not performed its duty to mitigate, which is contractually provided for, then the non-performing party will not be entirely excused from liability because this clause is enforceable as part of the larger force majeure clause, and the courts would indeed look into factors where the non-performing party has mitigated the impact of the unforeseen event or not.
Sure. There is also a question that whether there is any law under the contract related to suspension versus termination. So there is no specific law because I think you will have to see the clause like in the first example which Ashish discussed. The clause allowed a party to suspend in such an event, and then you may want to use that clause. The third question, which Kshama, I would like to you to answer, is a question which says, what if I don't give notice as required under the contract? Does the contract act require any notice? What is the actions that a party should take to make sure that he gets the benefit of force majeure?
A notice requirement is not there under the law, but then since force majeure is a contractual provision and there is if there is a requirement under the contract to give a notice to the other party, telling the other party that the event has occurred and is now in operation, the notice requirement must be complied with. The consequence of not complying with the notice requirement is that you haven't, as a non-performing party, informed the other party that an unforeseen event is now in operation. I will not be able to perform until the event is in operation. And following that, another notice to say that the event has ended, I can now resume my performance. So notice requirement needs to be complied with in order to invoke force majeure.
Sure. We have tried to cover some of the questions, but if there are more questions which are coming, please do post it on the chat. I think there is a follow-up question from Aditya Solanki, as I see, and it comes out of what Kshama was talking about, which is the Office Memorandum COVID-19 talks about.
All right. So for present purposes, I'll just continue over there. I think the question that Vyapak was last mentioning related to the one which was posted by Mr. Aditya Solanki related to office memorandum, which is there, which says that this is this current situation classifies as a natural calamity, and consequently, if there is an agreement which has a force majeure clause talking about act of God, would this generally be covered? Kshama, if you want, I'll take this up, or do you want to take it up?
Go ahead.
Sure. So possibly I can deal this with a couple of other questions which were there. In this context, and I see there are a couple of others in relation to the office memorandum, asking about whether this office memorandum can be relied upon in relation to the contracts which parties themselves have entered into. And there may be other government notification memorandums or advisories which will come out. Will those be relied upon by parties in their own contracts? We should remember one thing. Obviously, you can take advantages of such kind of statements which are there and use it to your benefit. However, you should remember that force majeure clause is a clause present in your contract. And therefore, the extent, scope, and application of that clause will depend upon the language of your contract. Typically, if there are multiple instances or things which have been identified in your contract, you have the principle of ejusdem generis, where you take and look at those words which are preceding and coming after those words, and to sort of interpret the contract. So you'll apply your principles of contractual interpretation to identify whether the particular present circumstances falls within its scope or not. Simply saying that there is a government notification and simply saying the government notification calls this situation a natural calamity, this is not actually a government notification. The government notification was issued for its own departments, for its own contracts. Obviously, you may try and take the benefit, but that cannot be the basis to sort of say in your own contract that this is force majeure. The second set of questions which I followed on this right were in relation to lease. What happens to lease of commercial properties? People are obviously facing difficulties in operating their shops, factories, or commercial offices, and those are basically shut. And therefore, what happens to my lease for this period? Do I continue to pay rent? Now, in this context, there is an interesting case. This is an old case in England, which is Henry versus Krell. What happened in that case was a person went out and leased a couple of rooms or of some hotel where the shop window said these rooms are available for viewing of king's procession post coronation. And king got ill, and therefore the procession for the king's coronation did not take place. The court and the person obviously did not occupy the rooms, and the question was, is he liable to pay the rent for those rooms? The court in that case held that this is a situation where the object behind those taking those rooms, as the windows were clearly said that these rooms are being let out to watch king's procession, was the object was entirely frustrated, and therefore the person could not claim rent, and the contract stood frustrated. Now, some parallel between that situation and the current situation can be drawn. Let me also say there has been some criticism of this judgment, and this is a fairly old English case, but you will have to evaluate the language of your lease or rental agreements to see does it specify the purpose of rental, how is it being worded, if there is a clause or not, and what is the nature of frustration, and to see what will be its impact. I think the notification point Kshama dealt with, and Vyapak, I think you're back. I can hear some words from you, so probably if you want to continue there.
That's correct. Sorry, I got disconnected, but I'm back again. So I think there was one last question that I see, which is in relation to loan agreement, where it says from Mayank that typically a FM clause is not included in term loan agreement. Can a borrower claim FM and defer its repayment obligation? If yes, what all rights are available to the lender? Whether lender can claim the EOD and enforce the security. Simone, you have dealt with several of the situations in advising a lot of corporates, typically, doing stress deals or otherwise. You have any thoughts on this?
I think unfortunately borrowers are not necessarily exempted from performing their obligations as a result of a force majeure clause. But I think the good news is that the Reserve Bank of India has in fact looked at this and is looking at this carefully. Is perhaps will come up with some sort of guidelines in terms of classification of these loans as and not as NPAs and so on and so forth, which may allow for lenders to be able to look at this more humanely and see what extensions can be given to borrowers. But on the face of it, without a force majeure clause in the contract, without an impossibility to perform, which typically would never be the case in a borrower or in a lender document, it is not possible for the borrower to claim a force majeure. Like we discussed in the past, it's not impossible for you to perform this contract before Section 56 does not come into place. And unfortunately, borrowers are not exempt. Can lenders sort of enforce security interests? The answer to that is, it really depends on how the contract is really worded. Just because there is a pandemic doesn't give you any right. If the borrower is still paying its dues, if the borrower is making good, and there are, for instance, cure provisions under the contract, and the borrower is following those provisions, then just the mere fact that there is a pandemic doesn't give the lender any right, and therefore it has to be looked at in terms of the contract specifically. But yes, if the lender wants no relief to be granted, and the borrower fails to pay by virtue of the contract, then does the lender have the rights under the terms of that contract? The answer to that is it appears to be yes.
Sure. So I think there are also follow-up questions coming based on the answers, and law being the way it is and the uncertainty that we all are facing. I think there will be enough debates and discussions around it, but we promise that I think Rajiv's second part of the question he feels has not been answered, but we promise that we'll take up each and every question and personally respond to each of you separately after this call. And if required, we can also, give little more material around this, to explain some of these positions which, are not as clear as we want. In fact, some of the leading judgments that we are relying on are of 50s and 60s in India, and some of them in UK are even, early 90s. So obviously, we are now talking about situations which are completely different, and the effect of which has spread across the world. Possibly the kind of spread it is for the first time that the world is facing, and the kind of measures and responses the governments are making are also unique in its own way. Nowhere ever government has responded in this fashion, and therefore I don't know how much of that would be in whose favor and who's against, depending upon which situation you are. So we are very close to 4 p.m. now. I know there are questions more unanswered than answered, which is in a way a good situation to have, that we will continue to have a chat with you. But maybe I'll bring in Devanshi back if you want to continue this session a little longer, or we may want to hold this session again sometime this week to continue this chat. And as I promised, we'll definitely respond to each one of you individually after this session.
Yeah. And there will be an email sort of address that is circulated. If there are any additional questions, do email us on at nda@nishithdesai.com. We will have that sort of email circulated. And I think the entire week is going to be multitude of webinars similar to this one, which has more specific topics, force measure, and also from a COVID-19 perspective in terms of what industries, etc. it would affect. Do join us for each of these. It will be sort of helpful to also understand from all of you the problems that you are facing, so that we can also provide bespoke sort of advice and be ready with what is likely to happen in the next few months.
Sure. So Priya Bahel, I think, has asked a question in relation to employment of the new hires and can we postpone. Now, without taking too much of time, today 9 p.m., some of these questions will be answered in the session which we are taking. We will have our head of our employment practice, Vikram Shroff, joining. So it is the best time to grab him for such questions.